Hi, welcome along. You're joining Chris Sutton and Simon Fenton of Fenton Elliott Solicitors. This week we're going to be talking about employment tribunals and when people might find themselves facing an employment tribunal hearing and what they do next. Simon, what kind of situation might lead someone to end up in an employment tribunal?
Conflict. It's about conflict. So an employment tribunal is another name for a specialist court that deals with disputes arising from employment, generally speaking. There are some exceptions, but generally speaking, it's about employers and employees who have fallen out and are unhappy with each other and want some kind of redress and need to go to court or tribunal to prove their case and to get some compensation.
Who's taking who to this tribunal? Is this employees taking their employer, or is this an employer saying, I've not been getting enough out of my employee?
So this is employees suing their employer. Now, there are circumstances where the employer can sue back. So an employee typically will sue for unfair dismissal or some kind of discrimination. But if it's a contract claim, breach of contract, then the employer can counterclaim in the employment tribunal. It doesn't happen very often, but it is possible. So really, it's about employees enforcing their rights against employers. They feel hard done by, and they think this isn't fair, and that shouldn't happen, and I should be compensated for the way I was treated.
Okay, so is taking your employer to a tribunal the first port of call, or is this a last resort?
For some people, they're trigger happy and they're just going to go for it. Before you get to an employment tribunal, you have to lodge your unhappiness with ACAS, which is the conciliation service, and they will attempt, if you want, to broker a negotiated settlement with your employer. So you contact them, you tell them what it's about. They say, would you like me to seek to negotiate a settlement? The employee generally will say, well, go on then, give it a go. The ACAS will then contact the employer and say, look, you've got a disgruntled former employee. Do you want to settle this? Tell me about it. What's going on? Do you want to settle this? Now, sometimes that works and the matter just resolves and goes away. A lot of the time it doesn't. But you can't lodge a claim with an employment tribunal without a certificate from ACAS saying, we tried.
You mentioned it was an former employee taking their former employer to a tribunal. Do you have many cases where it's a current employee taking their current employer to a tribunal?
It can happen. It absolutely can happen. Generally speaking, it's not a happy thing for an employee to do, to be suing their employer and still rocking up to work and the Christmas party and showing enthusiasm. If they've been discriminated against, they can seek redress in an employment tribunal while remaining in employment. But it's quite unusual. To do that is really pulling the pin on a big hand grenade that goes in that relationship. And it's very common actually, thinking about it, that an employee will sue for unfair dismissal and discrimination, if there is any discrimination, and possibly breach of contract, and 2 or 3 other things, the whistleblowing perhaps, that they can sue for, and maybe sue for 4 or 5 different things in the one case.
Once you've got 4 or 5 avenues of claim, this is all sounding quite complicated. Do all employees need a lawyer to go to a tribunal?
Nobody needs a lawyer to go to a tribunal. You can rock up to a tribunal without a lawyer. I mean, honestly, your prospects of success are greater with a lawyer, and the law can be quite complicated. Tribunals were set up in the 60s. They were called industrial tribunals. They've been employment tribunals for 20 years, but people still call them industrial tribunals sometimes. And they were meant to be an informal way of resolving workplace disputes. But then they say, well, so this case was decided on this basis, so that's the way future cases should be decided, on that basis. That's called precedence, right? So one case is decided like that, so future courts will decide them on the same way. As soon as you have precedence, you have lawyers who go, well, the court case said that, so that's what you should do. You get lawyers involved, it gets complicated. The more complicated it gets, the more the government system feels it's okay to have really technical laws that, frankly, only lawyers can understand. And when that gets involved, obviously, you're better off with a lawyer, and a specialist employment lawyer at that.
How much is it likely to cost an employee to engage getting some advice for a tribunal?
Well, it depends how much advice they want and how much assistance they want. So I could certainly, we get calls from people to say, look, this is what's happened. Do I have a case? And if somebody calls me and they've been employed for 6 months and they didn't pass their probation and they think it's unfair because their boss is a pig and they can't treat me like that, my advice would generally be fairly quick in that you can't sue for unfair dismissal unless you've been employed for 2 years. Now, I'm not going to charge somebody for that advice. If the advice is, look, spend your time and energy looking for another job, not dwelling on how badly it went in the last place. That's not a good use of your time. And I'm not going to charge somebody for that kind of advice. But if you need a case putting together and legal documents drafting and representation all the way through to a hearing and at the hearing, it could be 20 grand. It could be less. It could be as much as, it depends how complicated it is, how long the hearing is. It also depends to a very large extent on the response of the other side. It's like a game of chess. How long is a game of chess?
Hours, potentially.
Yeah, hours, potentially. Or 10 minutes if you're really good and they're not. So it's that sort of thing. The longer it takes, the more input we have. We charge on a time basis, so the more time we spend, the more expensive it gets.
Who's making the decisions in these tribunals? What's the panel made up of?
The panel is usually an employment judge sitting alone. And the employment judge will be a solicitor or a barrister, a specialist who goes through special training and acts as a judge. A lot of judges are part-time judges, so there'll be a practicing solicitor who does 2 days a month, or barrister who does a couple of days a month, or full-time judges. Where there's a case of discrimination, there will usually, almost always, be a panel. And the panel will comprise of 3 people, so there'll be the judge in the middle. There'll be somebody who is representative, not representative, but sort of from the perspective of an employer, and somebody who comes from the perspective of an employee. So it might be a trade union rep and somebody who sits on the is a member of the Confederation of British Industry or was a big company HR person. So you'll get a perspective. Everybody there acts impartially. They just come at it from different angles. And for discrimination claims particularly, if it's sex discrimination, you might have somebody with experience of that, or disability discrimination, somebody with experience of that, so that they can bring expertise to the case.
How long does it take to litigate a matter from beginning to end through the tribunal?
Like a lot of things, since about the financial crash of 2008, the courts and tribunals have been starved of cash, not enough judges, not enough court time, not enough courts. So back in the early 2000s, 6 months, which was quite quick. So you got 3 months to sue, and then you could be in court 3 months later with all your ducks in a row and witness statements and documents disclosed. Now, 18 months, maybe 2 years.
Wow.
It's a long time.
That is a really long time.
Yeah. It's not like we're doing stuff the whole time. There's a flurry of activity at the beginning. There's a lump in the middle where we might have to disclose documents or put bundles together. And then there's the time at the end. And obviously in those fallow periods in between, nothing gets done, nothing gets charged. So the cost is no greater because it's longer. It's just, you sit around and wait.
What's your one major bit of advice for, I guess, particularly an employee who's considering bringing a case against a former employer?
Okay, it has to be worth it. While you may be angry now, and that anger may drive you, that anger will dissipate over the course of 18 months, 2 years. Life will move on and you will get a new job, and this will just be another thing that's hanging over you from before. So it has to be worth it. Now, What that means is financially worth it. There has to be some really good reason, namely financial, why you're seeking financial compensation from your employer. If it's not worth it, then don't put yourself through the stress, frankly, and the cost of doing it.
Interesting. I've learned quite a lot about employment tribunals. It's clearly a complex area and somewhere you really do need expert advice if you're going to navigate those waters successfully. So, if you are in a situation where you're considering bringing a claim against a former employer, or indeed you're an employer who thinks they might need to defend a claim that's been brought against them, I think Simon's the perfect person to speak to. So reach out to Fenton Elliott Solicitors, and I'm sure the team will be able to assist.